Except for contracts that expressly provide otherwise, every contract for the sale of land contains either an express or implied promise that the seller will deliver marketable title to the buyer at closing. Virginia's highest court considered whether a line of sight easement made the title to a farm unmarketable in the 2002 case Haisfield v. Lape. Kenneth and Barbara Lape owned land in Albemarle County, Virginia, known as Oakmont Farm. In the mid-90s, the Lapes conveyed a portion of Oakmont Farm to Dr. Hamilton Moses III and Alexandra G. Moses. Thus, Oakmont Farm became two separate parcels. There was Oakmont Farm, owned by the Moseses, and Laurel Ridge Farm, owned by the Lapes. The deed from the Lapes to the Moseses contained a line of sight easement, also called a view easement, which restricted the Lapes from building any structure on Laurel Ridge Farm visible from the main house on Oakmont Farm. In 2000, the Lapes entered into a land sale contract to sell Laurel Ridge Farm to Audrey Lee Haisfield. Paragraph 14 of the purchase agreement promised that the Lapes would convey Laurel Ridge Farm free of encumbrances, but nevertheless subject to any restrictive covenants not making title unmarketable. Haisfield made an earnest money deposit of $50,000, which the Lapes were entitled to keep as liquidated damages if Haisfield defaulted or breached the purchase agreement. The day before closing, Haisfield informed the Lapes that the line of sight easement, found in the chain of title to Laurel Ridge Farm, was a restrictive covenant that made the Lapes' title unmarketable. Haisfield gave the Lapes 60 days pursuant to paragraph 14 of the purchase agreement to cure the defect created by the easement. Haisfield further maintained that she was justified in refusing to close the transaction and was entitled to the return of her deposit if the Lapes failed to cure the defect. The Lapes disagreed that the easement made title to Laurel Ridge Farm unmarketable. They sued Haisfield, claiming that Haisfield breached the purchase agreement by refusing to close the transaction and claiming the $50,000 plus interest as liquidated damages for the breach. The trial court entered judgment for the Lapes, and Haisfield appealed to the Virginia Supreme Court.